Hello everyone, welcome back to another new episode of previous year question and answer discussion. Today we are going to cover the CRPC portion of 2016 and 2017 prelims examination. So without any delay, let us start. The first question is, under which section of CRPC the term offence has been defined? The answer would be option B, section 2N. 2O talks about the officer in charge of police station, and here section 40 talks about the offence under IPC. Now question 2 is regarding the proclamation. A proclaimed person whose property has been attached can claim the property or sale proceeds on appearance within 6 months of attachment, 1 year of attachment, 2 years of attachment, and 3 years of attachment. This is option C, 2 years of attachment as per section 85 subsection 3 of CRPC. Next is minimum number of judges of High Court required to sign confirmation of death sentence. This is again a direct question. The answer is option B as per section 369 of CRPC. We all know that the death sentence need to be clarified or confirmed from High Court if it is passed by the Sessions Judge. Now question 4 is regarding transit remand means. Transit remand means the option C, taking accused by police from one state to another state as per section 80 of CRPC. Question number 5 talks about which one of the following section of CRPC provides for free legal aid to the accused. This is again a direct question. The correct option would be option number D, section 304 of CRPC. You can also relate it with article 39A of Indian Constitution. Now question number 6 is regarding classification of compoundable and non-compoundable offences has been provided under section 320 of CRPC. Question number 7. Which section of CRPC provides for compensation to groundlessly arrested person? This is again a direct question. The correct answer would be section 358, that is option C. Question number 8 talks about the provisions of CRPC other than those relating to chapter 8, 10 and 11 shall not apply in which of the following states? This is again a direct question. If you refer to section 1 subsection 2, the correct answer would be option D, Nagaland. Again in question number 9, which of the following is not an essential procedural requirement of section 164 CRPC? We all know that 164 CRPC talks about recording the statement for such as the confession or any other statement of witnesses or the accused or the victim. The procedural requirements is given. The option A is confession to be made voluntarily. Option B is warning to the accused, recording of confession in option number C, in presence of advocate of the accused, and lastly memorandum of at the foot of confession. This is a mandatory provision. Option A is also mandatory and option B is also mandatory if the presence of advocate is not required. So the correct answer would be option C. Question number 10 talks about the provision proving previous conviction is envisaged in which of the following section of CRPC? Again, this is also a direct question. The correct answer would be option D, section 298. Question 11. An accused arrested can be kept in custody without producing him before the magistrate after his arrest for a period of, the correct answer would be option B, that is 24 hours as per section 57 of CRPC. And we all know that article 22 also talks about the same thing. But for preventive detention or preventive action, the second part of Article 22, there can be detention beyond 24 hours. For that, the confirmation from the board, a special board is required to be detained beyond 24 hours under Article 22. But the correct answer to this question would be as per section 57 of CRPC is option B. Question number 12 talks about section 41A, 41A and 41B, 41C and 41D were incorporated in the CRPC by, this is again a very factual question, the answer would be option C, 2008 amendment. Now next question, in which of the following case the Supreme Court held that no arrest can be made because it is lawful for the police officer to do so? The existence of the power to arrest is one thing and the justification or the exercise, it is quite another. The police officer must be able to justify the arrest apart from his power to do so. The correct citation for this ratio is option B, Joginder Kumar versus State of UP. Again, this is a very landmark case regarding the grounds of arrest, because by way of arresting we are legally curtailing the personal liberty of the person or of the accused. So that's why it need to be followed by proper guidelines. That is why such a requirement is there. The ratio is implicit under Joginder Kumar versus State of UP, that the arrest has to be justifiable. So question number 14 talks about when a police officer files a report under section 195(1)(a) of CRPC, it is known as, yes, it is known as a complaint. Then question number 15 talks about offences for which a police officer has no authority to arrest without warrant is called, again this is a direct question, the correct answer would be option B, non-cognizable offence by virtue of section 2L of CRPC. Question number 16, the accused filed an application before the magistrate to allow him to appear through his power of attorney holder. The magistrate allowed the petition. The order is, again this is based upon a case law, and the correct answer would be option B, illegal. So the correct citation would be AIR 1999, Supreme Court 1385. You can tell me the exact citation of this case law in the comment section below, and what is actually required as per section 273 is that during trial the presence of accused is a mandatory one unless it has been dispensed by the magistrate. I like given in 205 or 317 CRPC, where the judge or magistrate has the power to dispense with the personal attendance of the accused, but otherwise the presence of accused is mandatory under section 273. So a accused cannot be represented by a power of attorney holder. So as per this TC Mathai case, which is AIR 1999, Supreme Court 1385, it is actually held that such an order is illegal. You can refer to that case law to get a clear idea about this topic. Question number 16. Executive magistrate are appointed under dash of the Code of Criminal Procedure. Again, this is a direct question. The answer would be option A, section 20. Question number 18. Which of the following sections of the CRPC deals with conditional order for removal of nuisance? It is again also a direct question, section 133 of CRPC. Now, question number 19. Chapter 11 of the CRPC deals with maintenance to wives, children and parents, maintenance to public order and tranquility, preventive action of police, none of the above. This is also again a direct question. The correct answer would be preventive action of police, which ranges from 149 to 153. Preventive action of police. Maintenance, we all know that it falls under chapter 9 of CRPC. Our next question is question number 20. A new proviso was added to section 157(1) of the CRPC by the Code of Criminal Procedure Amendment Act 2008 in relation to an offence of It is again it was amended for the offence of rape. 20 subsection B, option B. So that's all for today. In our next episode, we will be discussing the previous year questions of 2016, 17, 18 we have covered. We will be dealing onwards 2019, 20 and 21. So till then, thank you.